to oppose any sort of release of Mr. McIver. The freedom to live out her life was unfairly and intentionally taken from her, and the lasting rippling effect of her loss lingers daily, not just in our office where she was so loved and respected and served as president, but even more as a very close friend and confidant. I so wanted to believe her death was an accident. However, the actions taken and shown by Mr. McIver proved otherwise. He showed no remorse, asking for her checkbook a day or two after her death, the immediate sale of her clothing and jewelry, seeking information on getting her Social Security benefits 3 days after her death, and the non-communication of her disposal, resting place, or even a simple celebration of the love, time he spent with her, or the so-called wonderful life they shared. In my belief, all showed that Diane's death was an intentional act committed by Mr. McIver.
Do you have a view on the elements I need to consider, which would be risk of flight or intimidating witnesses? You do? Okay.
I do. I remain firmly in my belief that the 12 jurors selected by both the DA's office and the defense team representing Mr. McIver heard and reviewed all the evidence presented, made an honest, unanimous, and correct decision to convict as to the crime Mr. McIver was charged. Therefore, on behalf of myself and all of those lives who were changed forever that awful day, who to this day still have no closure, I strongly oppose and plead with this court to not grant this bond in the name of justice for Diane McIver. Judge McBurney, it was not love that killed Diane McIver, but one silver bullet and 12 pounds of pressure. I do believe that he is a flight risk. I do believe that he is an danger to other people based on the actions that he showed. Thank you.
Thank you, Ms. Williams.
This is the last impact statements from Ms. Danny Jo Carter.
Okay. Hello again, Ms. Carter.
Hello, good morning.
Good morning.
My statement's been kind of, some of it's been cut out, so I hope I don't stumble. There are many things that I could tell you about how this man has impacted my life, but today is about the possibility for bond. I can tell you that in December of 2016, when he was released the first time, 2 of the conditions of his bond were to have no contact with me and to have no possession of firearms. Tex McIver did make contact with me, coming into my salon and getting his hair cut, sending me notes by messenger. I didn't report this because at the time I was not sure that it was not an accident. His behavior became more bizarre to me and disturbing, calling my husband, telling me to stop talking to the police, that I was going to have him put in prison. In the investigation by the district attorney's office, the Glock 19 was found in his sock drawer, but during a 3-day hearing, he accused Billy Corey of having planted the gun in the condo. The gun was registered to Tex's brother. His lying and manipulation resulted in the revocation of his bond, and he spent the last 8 months before trial in jail because he did not respect the conditions of his bond. His friends accused me of taking money from Billy Corey for my testimony. My testimony had nothing to do with his intentions or what was on his mind or in his heart. They were only the facts about what happened the days before, during, and after Diane's death. This is a fact. I am fearful of his release. I know he blames me and Billy Corey for his incarceration. This is a fact. He had no respect for the conditions of his bond the first time. I ask these questions. Why would he do so today? Why would you give the same man the opportunity to lie and manipulate? Thank you for this time.
You're very welcome, Ms. Carter. Thank you for being here. Mr. Bate, anything else from the state?
No, Your Honor, with all that, the state respectfully requests you deny defense counsel's motion for bond, as we do believe that he is a flight risk and that he does risk the intimidation or influencing of witnesses as he's done in the past and he was convicted for. So based upon all that, we respectfully request you deny defense counsel's motion for bond.
Okay. Ms. Clark Palmer or Mr. Samuel, welcome to round things out as the movement. at a minimum, I need you to further reorient me to those many years ago. I understood you to say, Mr. Samuel, in your opening comments, that at the time of trial, Mr. McIver was in fact on bond.
Sure.
So he had his, I remember the bond revocation. I was there for that.
Yeah.
So he had his bond revoked, and then at some point it was reinstated?
Correct.
Okay. We had some hearings about that? What, just I woke up one morning and signed a reinstatement, or what was the process that led to that, as best you remember?
I think the reason that I don't have a very clear memory was before Ms. Clark Palmer and I joined the defense team, but he was out on bond during the trial. He was out on bond before the trial. I can't remember the first day of trial, but it was February or March, and the bond order was January 16th of 2018. That's when you
Okay.
reinstated bond.
Okay.
And you signed this, and I've got a copy of it.
I don't doubt you at all. You wouldn't have said it if it's not what the paperwork said. I just was wondering if it was the passage of time because we hadn't been able to get to trial, what it was. I remember why I revoked the bond. I remember that hearing very clearly.
That's
and
right.
the efforts of previous counsel to blame everyone else in Mr. McIver's life for the gun being in his sock drawer.
Right.
Didn't work out well.
That's right. But you reinstated bond. So
Right.
so you
Just
obviously,
wondering why.
I'm sorry.
I was just wondering why.
I recall.
Okay, well, I'm asking Mr. Samuel right now. and then-
If Mr. Abadi was there, maybe he could enlighten me too, because
Okay.
I believe it was before I got in the case. Ms. Clark Palmer and I got in the case either mid or late December of 2017 or early 18. The order is January 16th, 2018. I don't believe I was here for the bond reinstatement hearing. Amanda, do you remember?
You would take credit for it, I'm sure, if you got the bond reinstated.
I believe that's true. My guess is that Mr. Harvey was clearly here because he was involved even earlier.
Okay.
He's in another courtroom today, so
So,
couldn't avoid that.
all right.
If Mr.
What do you remember, Mr. Bate, about why bond was reinstated?
The bond was reinstated, so I believe the last bond hearing was the June 6th of 2017 hearing. I believe it was 42 or 43 days after you had revoked the bond, after the April 21st, 25th, and 26th 3-day motion to revoke bond hearing where you actually did revoke the bond due to the circumstances. At that point, Mr. McIver remained in custody. You had listened to a couple jail calls, 3 being, I think 1, Mr. McIver referencing, just call Judge Schwall and he'll get me out, 2, he was talking about providing a Jaguar to Mr. Hughes because, you've got to feed little birdies or something along those lines. And then the reason, so he remained in custody, you kept your ruling in abeyance, and then all the documents that were seized from Mr. McIver's residences remained, I believe, in your jury room. And the taint team was trying to go through everything as fast as they could. It was a private firm, Nelson and Mullins, who was doing that, and due to the voluminous amount of documents, both sides needed an opportunity to fully go through it and argue about whether it was privileged, not privileged, and things of that nature. So the trial was delayed, and that's when, after the trial was delayed, you reinstated bond. And I believe that's when both Mr. Harvey and Mr. Samuels took the place of Mr. I think Alex Barco, and then
And Judge Hill.
former Judge Hill, yes.
And I'm sorry, if she's done. I'm realizing now this January 18th order amended the bond order to allow him to come to our office. So this isn't when he was readmitted, the January 2018 bond order. It was actually quite a bit earlier.
Right, and I'm remembering now. It was the delay occasioned by the necessity of having a tank team to make sure that there weren't protected
I recall that too.
materials, privileged materials inadvertently disclosed to the state. And
Right.
Nelson Mullins did its best to get through that, but it took long enough that I view that as a state delay, not purposeful, necessary, and that ought not to be a reason for Mr. McIver to stay in custody.
And I believe you reinstated bond originally, I think it was in October of 2017, because during the June bond motion, after he had been revoked, Mr. Rucker had indicated to the court that the state intended to have the trial sometime in September, I think it was September 18th actually, of 2017. But unfortunately, due to the delay of Nelson and Mullins having to go through to sift through all the documents that were seized at both his residence. That delayed the trial, and that's when esteemed counsel joined.
Okay, so, just so the record is clear, Mr. Clark Palmer says that he was readmitted to bond in October of 17. So he was out for, close to 6 months prior to trial. Whatever the cause was, he was out for 6 months. And there was no flight, and there was no danger to the community during that period of time. Let me just, I don't think I need to respond to what some of the witnesses said. Obviously, they're displeased with the Supreme Court. But those of us who are members of the bar know that when the Supreme Court rules, we don't question, A, their wisdom, and second of all, it's meaningful. I'm not going to sit here and brag about the practice of law, about the Supreme Court, but they made findings which negated the conviction. And for the state, which did this in their pleading, to say, well, 12 people decided this case. And then the Supreme Court reverses it and said they decided it without having been properly instructed, hearing inadmissible evidence, more than one item, the hospital evidence and the second will evidence, criticizing the prosecution for some of its, at least close to being racial evidence that was introduced, including the PowerPoint. Maybe you disagree with the Supreme Court's decision. I'm sure all the witnesses disagree, but that's, that's the way we practice law in this state and in this country. The Supreme Court said, in essence, and I may be overstating it somewhat, the trial was unfair. And that's why we get a new trial on these counts of the indictment. And that's meaningful. It means something. And I know you don't, to use a non-legal expression, poo-poo it. The prosecution apparently does. They repeat again today. Well, 12 people decided this case. Well, why did we bother appealing? Why does the state even bother participating in an appeal if the 12 people is all it takes to lead this man who's now presumed innocent of every remaining charge in this case to stay in jail? So I disagree with the prosecution's argument, and the witnesses, of course, are not lawyers, and I understand that they have an emotional tie to this case. But for what it's worth, the jury acquitted him of malice murder. If you want to talk about what the jury did, they acquitted him of malice murder, which makes it a very complicated verdict to try to unravel here. Found him guilty of intending to shoot, but not guilty of intending to kill. 12 jurors. If you want to talk about the jury's verdict, if it's meaningful at all, they found him that he didn't intend to shoot and kill Ms. McIver. So I don't put a whole lot of stock in that, but it certainly is contrary to what the state's arguing when they say, well, 12 people already found him guilty of murder. And you directed a verdict on 2 counts. The remaining count that was sustained, the Danny Joe Carter count, I'm sure you remember, we all remember, it was a bizarre set of facts. We're at the hospital within 20 minutes of arriving at the hospital, or with an hour of arriving at the hospital, where he was in the back seat and the gun was in his possession and was shot. And Danny Joe Carter is driving the car. He supposedly tells her, and the jury convicted him, tell him you weren't driving the car. Tell him you just showed up, as if the car came in on a spaceship or something. It didn't make a lot of sense. It obviously was not a methodical effort to obstruct justice. Even if he did say that, it's completely nonsensical, and I don't think it. And he has now served 5 years for that conduct. That one statement, he served 5 years in prison for. And I don't think that is evidence of an intent to influence witnesses in the future. If nothing else, the fact that he was convicted and served 5 years would strongly counsel against having any contact with any witnesses. With regard to many of the other incidents that were discussed by Mr. Body and by some of the witnesses, those were all known to the court and to the prosecution, both in the fall of 2017 and in the winter of 2018, and you still admitted him to bond. And obviously, given the fact that the communications with Mr. Cardwell and Danny Joe Carter Ms. Carter had already occurred. You found he was still not a flight risk and still not a danger to the community, and admitted him to bond, and he performed without any problem whatsoever after he was admitted to bond. He showed up for trial every day, he was on time, and certainly had no contact with any witnesses. So these episodes that occurred before have already been considered by the court when you readmitted him to bond in the fall of 2017. Mr. Abadi puts some significance to the fact that he's 80 years old. I'm not quite sure what the significance is of that. I don't know what that means, but I can't even fathom how to respond to that. Yes, he's 80 years old. I would have said the same thing to you. I don't think that makes him more of a flight risk because he's 80, I don't understand how that would influence the court's decision here. We think that the most important fact is, at this point, he is presumed innocent, and he performed on bond after you released him in the fall of 2017. He stands ready for trial, and we will be prepared for trial when you set it, and we think that conditions can easily be set that respect the presumption of innocence as opposed to the presumption of guilt, which the prosecution is asking you to influence your decision here today. And if you have questions about conditions,
That's your partner.
that's my partner.
Got it.
Can we have just one moment?
If the court thinks that for some reason that flight is something to even be considered at this point, we checked ahead of time about getting an ankle monitor, and he can get an ankle monitor, and we have a company that will, I don't know if it's a Georgia company, but it will do it in Texas. So, and pretrial has the ability to monitor ankle monitors in another state. Do I have that right? Yes. So
Okay.
I'm now the puppet, so.
You're doing a good
The
job
marionette,
apparently,
thank you.
because Ms. Clark Palmer didn't jump up again. All right, thank you. I appreciate the input from all the perspectives, the people who were affected by what happened in this case, the lawyers, etc. I'll start with agreeing with Mr. Samuels that we are guided by the Supreme Court's wisdom. We're also bound by the Supreme Court's wisdom, and they ruled what they ruled. My evolving interpretation of the 100-plus page opinion that said it was a bad idea to rely on what seemed to be fairly clear-cut Supreme Court precedents, and deciding that the jury should not be charged on misdemeanor involuntary manslaughter, is that even though a jury that decided that the lower level of culpability of recklessness, that it was an accident, a jury decided this was not an accident, it was harmful error for the jury to not hear about an even lower level of culpability, as if that lower level would have somehow been a meaningful option for the jury. And the Supreme Court has said that it would have been meaningful for this jury, and it was error for the jury not to learn about an even lower level of culpability, despite the fact that they rejected the medium level of culpability and concluded that the shooting was not an accident, after hearing evidence and argument from the best lawyers in Georgia. But we remain bound and guided by the wisdom of the Supreme Court. Mr. McIver sits before me with a presumption of innocence as to the 3 remaining charges. He does not sit before me, though, as a blank slate or someone about whom I know nothing. It was very helpful to be reminded why bond was reinstated. Bond was revoked for an important reason. It was revoked because Mr. McIver demonstrated he was unwilling to comply with the conditions of bond, to include a very important one for his safety and the safety of others in a case that involved shooting someone. He had a gun again. But I felt that it was necessary to undo that decision when the state was unable or unwilling to proceed in a timely manner. And that was more a recognition of Mr. McIver ought not to sit in custody because the state's not ready. Today, we have the state announcing it's ready, the state saying, please specially set this case. I also have before me a man who has heard a jury say you are guilty of felony murder and will spend the rest of your natural life in jail. Not quite accurate. You'd be eligible for parole after 30 years, and you might outlive everyone's expectations and be around for a parole hearing, but effectively you were sentenced to jail for the rest of your life. I think it is reasonable and appropriate for me to consider that you, Mr. McIver, never, ever want to hear that again. And the best way to do that is to not come back. The best way to do that is to have a bond where you are living in Texas and you can disappear. You are a man of means. Mr. Samuel has represented men of means who, when they heard something not good about their case, disappeared to another country for years. Ankle monitors don't keep people around. I've had too many defendants cut their ankle monitors and disappear. I had a defendant, Mr. Harvey was represented, and he made it through about half the trial and didn't like where things were going. And we heard that that ankle monitor was heading southbound on 75 away from Atlanta, and then they found the ankle monitor on the side of the road. And that young man was a fugitive for 3 or 4 years, now spending the rest of his life in jail. You don't have to be a fugitive for very long to enjoy the rest of your life a free man. And that worries me. To me, that is a powerful incentive for you, Mr. McIver, not to come back to court to face much of the same evidence. I appreciate that some evidence has been excluded. I appreciate the observations of the Supreme Court that the case may have been weak or thin. The state's going to need to work with what it has. The charges remain, and the state is ready to proceed. I don't find that there is a set of conditions that I could impose that would guarantee or sufficiently assure me, Mr. McIver, that you will come to court for your trial, that while you are not in court but awaiting trial, that you wouldn't revert to things I've seen in the past, whether it's being around guns. It's sort of ironic that the state you'd go to is Texas, to not be around guns. I appreciate that your sister has no guns in her house at this time, or that there wouldn't be a reversion to trying to contact witnesses to have them think about the case from your perspective. You've got a track record with both those things that remains before me properly. Has nothing to do with the Supreme Court's ruling, but most of all, I am concerned about your willingness to return to court for your trial. And so at this point, I am not going to set bond. However, as before, if there is any date that needs to be continued because the state says we're not ready, then I invite your lawyers to remind me, as I am sure they will, that I've drawn a pretty bright line that your detention is in part contingent on the state's readiness. And if they back away from that, then we need to revisit this. And the second thing I'll say is that it may well be that your team, Mr. McIver, thought there would be a different outcome, and they may regroup and come up with a different set of conditions to include a location where you might live that is not many states away. And I'm happy to revisit this, not in a day and not in a week, but there may be a set of conditions that gives me the confidence that, number one, you'll be in court when it's time to try this case again. And then number two, no guns and not contacting witnesses or folks who are connected with this case. But as of now, I'm not comfortable that I could fashion a bond with a set of conditions that would allow me to have all those things occur. So with that, I will circle back with the attorneys soon to figure out if we can set a trial date, and that may also inform defense counsel as to how quickly they want to revisit questions of bond, because trial next May is very different from trial in December. I'll consult with my colleague down the hall about his case, because I certainly don't want to interfere with that. My understanding is that he has the audacious goal of trying it in January. And we'll see what happens. But I will coordinate with him and certainly keep the lawyers informed as to when we might next be able to move forward. Mr. Samuel, any questions about what I've just shared?
No, Your Honor.
Okay. Mr. Abate, anything from the state?
No, Your Honor.
All right, ladies and gentlemen, thank you for your time. We'll be in touch soon.
And there you just heard the latest on the ruling for Tex McIver for this bond hearing. I want to take you through just a little bit of background. Now, if you remember back in 2016 during his trial, McIver was convicted of influencing a witness. He was sentenced to 5 years in prison for that offense, which he recently completed that sentence just last month, but he has been in jail since, hoping to get a bond, which is what this hearing that you were tuning into was just about, hoping to get that bond talking with the judge, explaining his case. Obviously, we heard from a lot of people in that courtroom who were impacted by this story of McIver and his wife Diane, who were in a car being driven by a friend. Now, from the backseat of that car, McIver expressed concerns about safety in the area that they were in. That's when he allegedly asked his wife to hand him a gun from the front console. Minutes later, the gun fired, hitting her in the back. Now, the big question, of course, did he intentionally kill his wife? That murder conviction was overturned. Now the Fulton County judge, the DA, turns to the bond hearing and talking about whether Tex McIver, who by the way is 79 years old, will walk free. Now we're taking a look at this courtroom here. I want to continue to bring you this live room as people are walking out. Just remembering in 2016 the national headlines this trial made. Of course, this is a conversation we're going to continue to have and a story we will follow on our website, atlantanewsfirst.com. Make sure you check it out. If you download the Atlanta News First app, any new information that we gain from the Fulton County judge, who we're expecting to hear from down the line, from attorneys, we are going to be pushing that out to the app so that you can stay up to date through those push notifications.